Hello, everyone, and thank you guys so much for joining us here today for our weekly webinar. And today we're going to be discussing on when to apply for an I-601 waiver, fraud, misrepresentation, unlawful presence, criminal grounds, and alien smuggling. This is a really interesting topic, so we're so excited to be able to share this with you all. And a round of applause, I have here our managing attorney, Ruby Powers. She has been licensed since 2008, founded our firm November 2009. She is a board certified immigration attorney. So she's just doing great in the immigration community. Thank you again for all that you do and your advocacy, Attorney Powers. I'm going to let you take it away on the learning objectives and what is an I-601?
All right, so this is a form. And so we usually just talk about it in terms of the form. And so that's the reason why we say I-601 form. And let me go back, waiver, and let me go back for a second. My very first position after becoming an attorney 13 years ago, I worked at a firm that did almost only waivers. And so I got really good with it because I was learning from the best, and I had the opportunity to do almost all waivers all the time. I was preparing one a week or something like that. And so, or maybe more. And we were just constantly, and we wrote really long briefs at that time before the extreme hardship standard was clarified. So that's the reason where I have a love for waivers, and it's not, and gain that skill set. And not all attorneys and firms have a lot of experience or do as many on a regular basis. So that's also when you're looking for a firm, you want to make sure that they have experience and has a similar case, and that you know that they have, they're competent and skilled to succeed in your type of case. So the I-601 is a form, and we're going to go over who can file, what can be waived, criminal grounds, what is the hardship, how to prove who's a qualifying relative, and how long is the waiver valid for, and other things to consider. So the application for waiver of grounds of inadmissibility allows a non-citizen alien to, and that's the term that USCIS or immigration uses, and I believe they're starting to change that language, to immigrate to the United States, adjust their status to permanent residency, or seek admission to the US in a non-immigrant status if certain grounds of inadmissibility, circumstances, or conduct prevent them from being otherwise admissible. This applies to certain immigrants who believe that they are ineligible for admission based on certain grounds of inadmissibility. Inadmissibility is just a fancy word for like a blemish or a problem area. And there's a whole long list of all of those in the Immigration Nationality Act. And I recently spoke to a law school in town, and the way I explain it, I teach it on waivers there, is that the government is scanning you. They're scanning it sort of like a scanning machine. Bzz, bzz, bzz. I like to make that sound because it seems more real. And they're trying to see if you have any problems that would keep you from coming in. What makes you inadmissible? Like, we're not going to let you in. So in preventing the admission, right? That's all it means. So you have to figure out what's the perceived or real inadmissibility, and then you need to figure out, is there a waiver for that? And then you ask yourself, are you eligible for that waiver? So a lot of times what people often learn about these things, they're told at the consulate, you need an I-601 waiver if they didn't have an attorney before and they didn't prepare knowing that in advance they're going to need one. Or maybe they filed something here in the United States for adjustment of status, and then they're told on a request for evidence or notice of intent to deny or something like that that says you need an I-601 waiver. And so it can get complicated, and it can be scary if you're learning about it after the fact instead of in advance. So basically, if you're an immigrant or K or V non-immigrant visa, and you're outside the US, you've had a visa interview. So you have to have that. If you're outside, you need to have the visa interview where they tell you what your inadmissibilities are. You can't submit the waiver before you know what those inadmissibilities are, with very few exceptions. And you were found, or an applicant for adjustment of status, like I was mentioning, where you need to submit this waiver, or you've been told that you need to. So these are the different inadmissibilities. It could be for health-related grounds, certain criminal grounds, immigration fraud and misrepresentation, which is one of the top two that we see the most. Immigrant membership in totalitarian party alien smuggler. Alien smuggling sounds really scary, but for the most part, it's generally assisting, aiding, and abetting someone to enter or get into the United States. And that has been interpreted very broadly over the last many years, but we continue to monitor that to see if they will continue to do so under this new administration. There's also the other big one, which is the unlawful presence. Now, I just taught a topic to law school recently, so I'm being a little nerdy on this, but basically unlawful presence started on April 1st, 1997. So that's really when I need to know, or any immigration attorney needs to know, when did you enter, when did you leave? It all starts really predominantly from April 1st, 1997. You can also submit these if you have TPS or NACARA, VAWA, SIJ. There's lots of other scenarios that you can submit waivers for. And the I-601, which I need to clarify, is used for lots of different inadmissibilities. So it can be confusing, even for immigration attorneys. It lists a whole bunch of inadmissibilities, and depending on that inadmissibility, it changes the standard that you have to prove and who the qualifying relative would be. So under criminal grounds, you use the I-601 for different reasons. One would be like a simple possession of 30 grams or less of marijuana. The other could be 2 or more convictions other than political ones where the sentence or confinement was 5 years or more. Conviction of prostitution, unlawful commercialized vice, as well as serious criminal activity involving immunity from prosecution. You may apply for a waiver of inadmissibility if it's at least 15 years have passed since the activity and event made you inadmissible. So this generally, when you're doing a criminal waiver, the qualifying relative can include a U.S. citizen or legal permanent resident, spouse, parent, or child for most of the criminal waivers. So you can use children, but when we talk about unlawful presence and misrep, it does not include children. People get really confused there. So let's just say it's easier to have qualifying relative possibilities for criminal grounds, but not so much for unlawful presence and misrep. And so here we go into the next topic, which is where we see a lot more of them as well, unlawful presence. So this one, unlawful presence, we have to know your entries and exits. We need to know what status you are and how old you were. We have to know a lot of information, and we ask a lot of that in the consultation and intake. So if the 2 reasons we normally do I-601s are for unlawful presence or fraud and misrepresentation, and occasionally the alien smuggling. We don't often see as many as the health-related or the criminal grounds, but they do exist. So for the unlawful presence and misrepresentation, the extreme hardship standard is the one to meet, that the U.S. citizen or legal permanent resident, spouse or parent, or U.S. citizen fiance, would suffer extreme hardship if the immigrant could not stay in the U.S. They cannot either live without them or they cannot relocate to their home country. So you have to prove one of those 2 prongs. Those are the ones that's the most common, unlawful presence and misrepresentation and fraud. And note that you have to have a U.S. citizen or legal permanent resident, spouse or parent. It does not say child, and that is where people make mistakes. So you have to have a U.S. citizen, spouse, parent, or fiance, or legal permanent resident, spouse, or parent. Now, alien smuggling, as we mentioned, as another form of inadmissibility, has a different standard. It is family unity. And sometimes, depending on who the person was charged with smuggling, they might not be eligible. If it's like a brother or cousin that the person is being told that they were smuggling, then they're not eligible for the alien smuggling waiver. So you really have to look at the details of the charge to see, are they having an inadmissibility or perceived or real? And then is there a waiver for that problem, that inadmissibility? And if so, do you qualify for it? Those are the big questions that we're asking. So who are considered qualifying relatives? As we've mentioned, that U.S. citizen or legal permanent resident, spouse or parent for unlawful presence or misrep, and unlawful, it also can include U.S. citizen fiance, and the U.S. citizen or legal permanent resident who's a spouse, parent, or child when we're talking about criminal history. So just keep that in mind. And then what do you have to do to prove it? So a major element in obtaining a waiver is providing proof of the hardship. Factors that constitute extreme hardship include the relative would have to leave the U.S. to be with you. Everything we talk about, everything from finances, mortgages, education, profession. Maybe you have custody arrangement with a prior relationship and you need to stay close by and you have custody or you have to pay child support. The country conditions, if that country that you're from, the immigrant's from, has a TPS, that's also a really good reason. If the U.S. has already given TPS, they know that there's issues there in that country. If you're the qualifying relative is a primary caregiver for the elderly, disabled, or chronically ill, they're the only ones who can assist them. Those other consideration. Your education be significantly interrupted or terminated, losing employment opportunities, and primary caregiver for your children. A lot of people, we write a budget. What would happen if you could stay in the U.S.? What would happen if you had to move, if you had to stay, what's your budget now, and what would be your budget if you had to live between two countries? And almost always the number is ridiculously high because you'd have to work more to cover more costs and have more child care as well. So how long is the waiver valid? And I'll just say right before we close up on this aspect is that with a qualifying relative writes a statement explaining what would happen to them if the immigrant were not able to stay in the country. And then we go from there in terms of expanding and proving all of these possibilities. And the standard includes looking at the totality of the circumstances, which means that we're looking at everything all together. So how long is the waiver valid? If you're granted a waiver in connection with your visa, it's valid indefinitely. This is true even if you do not obtain the visa in the end. Yeah, I mean, I remember being asked this question at some point in the past, and I looked it up, and it was sort of crazy that it's there. But again, when you check off the box of what your admissibility is, that hopefully you check off all the boxes that could be perceived or possibility, because if you submit a waiver just for unlawful presence, but then they later find alien smuggling, then you're gonna have to submit another waiver unless you could somehow amend it. You have to be really good at, your attorney needs to be really good at screening your case before you even make a strategy of what to do with your waiver. Other things to consider, the filing fee, the I-601. And again, we're talking about I-601, not the I-601A, which is, we've done other talks on that one. But the I-601, the filing fee is $930, and that's just straight up to USCIS. That's Department of Homeland Security, not legal, not anything else. That's just the filing fee. And good news is the waiver is only taking 5 to 7 months. The I-601A is taking 2 years at the time of this recording, but the I-601 is only taking 5 to 7 months. So we covered a lot of territory, but we wanted to get you started with the concept. And we hope you're never told that you need an I-601 waiver, but if you do, we have a lot of experience. Even if you just want a second opinion or you want us to analyze your case, the best thing for consultation is to give us a copy of everything you was submitted, and let us know about the inadmissibility finding, and so we can analyze it. But we've done many a waiver over the many years, and would love to help people navigate this process so that they can become whole and be reunited and get their legal permanent residency status. So Dana, I think you can take it away.
Of course. Well, thank you all again so much for joining us. We do take pride in our success rate. I know Attorney Powers is a very knowledgeable attorney, but I could be biased. Again, if you all have missed or want to tune in any of our upcoming webinars, the next one is going to be October 15th on working in the U.S. non-immigrant employment-based visas. So, and there's the calendar up here up on the screen for our following webinar presentations. You can find them on our YouTube and on our Facebook. I would also suggest you guys follow us on our social media for regular immigration trends and update news, along with a little bit of Attorney Powers in the media. So thank you all again for joining us today, and we hope to see you all on the